talked about how she would write her opinions so that people that were just generally interested could just read the beginning of her opinion and understand what the basic ruling was, instead of having to try to decipher. Supreme Court opinions are difficult, even for judges and lawyers to understand. So she had this wonderful writing style that made it clear what she was trying to say.
Aloha kako. Welcome everyone to the Life and Legacy of Ruth Bader Ginsburg. Thank you for being here. I am Ronette, Kawakami, the Associate Dean for Student Services, William S. Richardson School of Law, and I'm going to be introducing everyone here. This presentation is sponsored by the William S. Richardson School of Law, the Hawai'i Community Foundation, Kamehameha Schools, the ACLU of Hawaii, and the UH Better Tomorrow Speaker Series. I'm going to introduce our esteemed panelists. First of all, we have Sylvia Law, who is the Elizabeth K. Dollard Professor of Law, Medicine and Psychiatry, Emerita at New York University. She is also the co-director of the Arthur Garfield Hayes Civil Liberties Program at NYU. Our next speaker is Andrea Freeman. She's a professor of law at William S. Richardson School of Law and a member of the Litigation Committee of the ACLU of Hawaii. And of course, our own Sabrina McKenna, who's an Associate Justice on the Hawaii Supreme Court. And I'm really pleased to introduce our new Dean, Camille Nelson. Thank you for being our moderator. So I've been asked to share just a brief personal story about Ruth Bader Ginsburg's visit to Richardson in 2017. Of course, she had been here two other times as our jurist in residence. But in 2017, I was very lucky and honored to be her guide and sort of her protector for about 4 or 5 days while she was here. And the story that I remember and that resonates with me was the first day after she did a public speech in our courtyard. And she came up right into this room, which is the Dean's conference room, but we had converted it to an office for her. And it was February 9th, and that was the day that the decision from the Ninth Circuit Court of Appeals came down with our own senior judge, Rick Clifton, who was on that three-judge panel. And the decision came down, and she was in here, she was on the phone with, I assume was Washington, D.C., but our phones all started blowing up. And I think, if I remember correctly, I think even Justice McKenna called me, and Judge Darlene Lendio called me and sent me a copy of the decision, of the opinion, because, you know, that's what women with law degrees do. We send each other these opinions, and it was just, everyone was excited about it. And Dean Sarfer was scrolling through my phone, reading the opinion while RBG was on the phone with DC. And as soon as she got off the phone, we told her the decision come down, and a big smile came across her face. And I was just about to say, send me your cell phone number so I can send you the opinion. And I realized, why would a Supreme Court justice give me their cell phone number? What a nut. So I got a copy, we got a hard copy for her. And I stuck my head into the conference room and I said, Justice, we're getting you a hard copy of the opinion. And she turned to me and she leaned against the desk, a lot like this picture here, just like that. She leaned against the desk and she looked at me and she said, good. That's my favorite memory of her visit here. So I'm going to now turn it over to Dean Nelson, and mahalo, thank you.
Thank you, Dean Kawakami. We greatly appreciate you starting this conversation. It's an incredible honor for me to be on this panel with these phenomenal women in celebration of the legacy and the life and the work of another phenomenal woman who is truly a legal icon. And with permission, I'd like to just share a part of a beautiful statement from our own Chief Justice of the Hawaii Supreme Court, Justice Rechtenwald, Chief Justice Rechtenwald. And he said, quote, Justice Ginsburg was a legal giant, a brilliant jurist who tirelessly worked to ensure that our nation's promise of justice for all was kept. She was also a courageous and inspirational role model, both professionally and personally, end quote. And what I'd like to start us off with is that personally part. the role model part. And I'm going to go in the following order and start this conversation with Professor Law, asking about you to talk some story, share some recollections and memories of that personal connection with the wonderful Justice Ruth Bader Ginsburg.
Thank you very much. So by the time the second wave of feminism hit the world in the mid-1960s, Ruth, following her wonderful husband Marty, had attended Harvard and Columbia law schools. There were only a handful of women, no students, no women faculty, and a pervasive environment of hostility to women. Clueless, but pervasive nonetheless. A decade later, when I went to law school, it wasn't that different. I can't really remember the first time I met Ruth, but there were so few women in the academy, in the civil rights bar, at the ACLU, that we all knew each other. We all knew each other. I wish I'd asked her to help me remember when we met, but I missed that opportunity. At both of her law schools, Columbia and Harvard, Ruth topped the class and served on the law review. And she did that while raising an infant and then a toddler and helping her husband Marty through a serious bout with fighting cancer. She was at the top of her class. She served on the law review at both of those schools, the only woman ever to do both. On graduation, she couldn't get an interview in New York firms or serious consideration at Columbia or NYU, so she went to teach at Rutgers. They paid her less than her male colleagues because she had a husband. She pushed back on that and won. So she felt the pain of sexism, but she also knew its deep structural roots. She was a student of Simone de Beauvoir. She had a grand vision, but also understood the need for strategy, prodigious hard work, and a team, indeed, an army. At Rutgers and then at Columbia, she worked with women law students around the country to create the first Women in the Law courses. In 1974, she co-authored with Irma Hill Kay the first case book on women's issues. She supported another group of women, her competitors, who became her friends, who produced another book. She helped found and support the National Women in the Law Conference. She and I were the only women on the original board of the Society of American Law Teachers. And I could go on like this. She was in the trenches when there were few women. In 1971, working with the New Jersey affiliate of the ACLU, she and her students wrote the brief in Reed v. Reed, the first Supreme Court case to hold that gender-based classification was not reasonable, was not a reasonable rule for picking an estate administrator. The court had previously rejected all challenges to gender classifications, many. She persuaded, on the wake of that victory, the ACLU to create the first subject matter project in the organization. They now have hundreds of them. And she led the ACLU Women's Rights Project for many years. I think only Thurgood Marshall amongst the Supreme Court justices shared her history of sustained strategic advocacy prior to coming to the court. Her approach, like his, combined a grand vision with a plan to take meticulously created baby steps. As an advocate, she transformed the constitutional understanding of gender and helped to reshape our culture. But in 1973, in Frontiero v. Richardson, she was only able to persuade 4 justices to vote for the proposition that gender classifications demanded strict scrutiny and a compelling justification. As a justice, she fixed that. in the United States v. Virginia, striking down VMI's male-only admissions policy, she did not insist on the formalistic words of strict scrutiny and compelling justification, but rather demanded exceedingly persuasive justifications and outlined the kinds of facts that would count in proving that she won. More richly than anyone I know, Ruth nurtured an army for justice. She welcomed students, clerks, young colleagues into a lifelong family of caring and companionship. She especially loved to officiate at weddings, gay or straight, once gay were possible. She used her magic pen to edit people's vows for them. Best were the weddings out in the country or at the beach. She would arrive in more recent years with her Secret Service in need of a room to work before she partied. She officiated at a wedding a few weeks ago while she was fighting off the cancer that eventually killed her. I'll stop there. We miss her.
Thank you so much, Professor Law. I want to underscore your words of creating and supporting and inspiring an army for justice. And I think she did just that. And with that, I want to ask Professor Freeman, how has the life and the work of Justice Ruth Bader Ginsburg impacted her personally in her work and in her personal journey?
Thank you. Well, I really feel so privileged to have had not just a woman, but a Jewish woman on the Supreme Court as someone to look up to. And those who know me know that I am very fanatic about movies. So when I had the opportunity to take my daughters to see On the Basis of Sex and show them that a female Jewish law professor could be the hero of a movie, it was a high point of my life, because not only did my kids see the importance of their mother's work, but also what they could be in the world. And that means everything to me. And I also want to highlight her impact on our students and just quickly share something that I put together after asking students one word that they would use to describe Justice Ginsburg. And this is the incredible map that came out of that question. And I think we cannot underestimate how important she is for every generation that has come after her and will be for the future generations, including our kids. Thanks.
Thank you, Professor Freeman, and thank you to our students who shared those brilliant and insightful words, deeply touching and quite insightful, so thank you for that. Justice McKenna, I know that you've also personally been inspired by and touched by the life and the legacy of Justice Ginsburg. Please share.
Yes, people like me, we stand on the shoulders of giants like RBG and Professor Sylvia Law. Thanks so much. And when you think about it, she is the first woman and the first Jewish person to lie in state at the United States Capitol. What an honor and what an inspiration. I obviously did not have a personal friendship with her, but I was honored to meet her several times here in Hawaii and in DC several years ago, where she hosted a fireside chat with her former law clerk and California Supreme Court Justice Goodwin Liu, and a dinner at the Supreme Court dining room for judges from the National Asia Pacific American Bar Association. I was just so honored to be able to sit and chat with her. And what a soft-spoken and just powerful woman. I remember the first time I met her was here in Hawaii, and I remember meeting her. It was at some function, and I remember she saying, "Judge McKenna, my husband Marty." And I remember, gosh, her husband was just, like the life of the party, just a really outgoing, friendly, talkative person compared to her, who was much more quiet, but just, you could see the soul, she was so powerful. And when I really kind of want to talk about what it must have been like for her, someone that was born in Brooklyn in 1933, And I was born in 1957, 24 years later. Those from the East Asian background understand that's 2 cycles. She was born in the year of the rooster, like I was, so we're both roosters. But anyway, as Professor Law has said, when she graduated from law school in 1959, she couldn't get a job. When first woman justice, Sandra Day O'Connor, graduated from Stanford Law in 1952, no law firm would hire her either. And it wasn't, in the 60s, women were they were discriminated against with impunity. And in 1964, the Title VII of the Civil Rights Act prohibited employment discrimination based on various categories, including sex, but discrimination against women in employment continued. RBG continued to experience discrimination even as a law professor, as Professor Law has indicated. And what's really important for the young people to understand that in 1970, only 4% of United States attorneys were women. It was 13,000 women lawyers in the United States. And in 1972, even though the Civil Rights Act in 1964 said women had to be hired, they weren't really being hired. And the other obstacle was education, because women couldn't even get into law school on the same basis. So the 1972 Title IX, which prohibited educational gender-based discrimination, which was co-sponsored by another powerful woman lawyer, Hawaii's own Patsy Takemoto Meek, made a huge difference, because that's when law school employment started to blossom. And law school enrollment by women. And just remember that in 1972, when Title IX passed, only 7% of United States law school graduates were women. So I'm just going to digress here, but so as a post-Title IX law school attendee, I have so much respect for the women that went to law school before Title IX. And that includes RBG, Justice Ginsburg, and it includes Professor Law. I have so much respect for the women that were admitted before Title IX. So, so Title IX made a huge difference in terms of employment of the number of women lawyers and the employment of women lawyers. By 1980, there were 62,000 women lawyers, 12.4%. As of 2019 now, the ABA Commission on Women in the Profession says that 38% of women lawyers in the United States are women. And I'll tell you that in Hawaii in 2019, it was actually 42%. So the path that people like Justice Ginsburg laid opened the door, and Professor Law laid for women like me, opened the door for all of us. But, I talk about Title VII, 1964, 1972, Title IX, but it wasn't just employment. There was still discrimination in so many areas. And so, as Professor Law has pointed out, Justice Ginsburg, before she became a judge, and remember, she started in the DC Circuit 1980 to 1993, considered a feeder court to the United States Supreme Court. And she was one of the early women judges on the federal bench. But in 1971, she wrote the brief in Reed versus Reed, which extended the Equal Protection Clause of the 14th Amendment to, talked about the fairness really, but 1973 Frontiero versus Richardson, that was a case for those of you who have seen the movies. That's the United States Air Force Lieutenant Sharon Frontiero, who couldn't get a dependence allowance for her husband, unless, because under military rules at that time, the military male spouse had to be more than 1/2 dependent on the female spouse to be military member to get a dependence allowance. She won that case. And, there was so much discrimination still. I think it was 1974 is when I graduated from high school. And let me tell you, even VMI, one of her first opinions, the Virginia Military Institute, opinion as a justice, that's when the Virginia Military Institute still wouldn't admit women. Some of the academies, military institutes had started accepting women voluntarily, but when I graduated from high school in 1974, the academies were still not accepting women. I went to a US military DOD school. I think it was like most of the top 10 were women, but it was a guy way down the list that got accepted to the Air Force Academy from my class. 1975, the Weinberger versus Wiesenfeld case, which permitted widows but not widowers to collect benefits while caring for minor children. Talk about that strategic, using a male plaintiff for a sex discrimination case. And, I'm going to digress here, but, this sex discrimination does go both ways, right? It's really important to recognize that. And in 1976, she wrote the amicus brief in the Craig versus Boren United States Supreme Court opinion, which challenged an Oklahoma statute that did not allow men under 21 to buy low alcohol content beer, 3.2% beer, but women over 18 could buy that beer. And in that case, it was so important, the United States Supreme Court recognized heightened scrutiny, intermediate scrutiny, under the Equal Protection Clause for gender-based discrimination. So what she was successful in doing was to make gender discrimination a constitutional issue. And that was so important. So, she has been such an inspiration for all of us. And so much of what she has done has led to allowing others that followed. And thank you to RBG and to Professor Law.
Thank you, Justice McKenna. And I would be remiss if I didn't also recognize you as a champion truly for justice as well, through your jurisprudence, through your service, through the ways in which you carry yourself in the world. We're absolutely grateful for the gracious ways in which you lead as well. And, when I think about Justice Ginsburg, I think about grace, and I think about just the tenacity and the quiet power of her voice, both in majority opinions, but also in dissents. And sometimes, that's a lonely place to be, and it can be isolating, but there's a power in that. And she certainly was the impetus through her dissents as well for change in our democratic society. And certainly I think some of that change might well be in the works in the decades to come. And I want to ask first Professor Freeman to comment on some of the dissents. And then I'm going to ask Justice McKenna, and then the same question to Professor Law. But Andrea, would you like to comment on Gratz and Adirond and Ritchie in particular?
Yeah, so I'm going to focus on Adirond and Gratz, which are affirmative action cases. And affirmative action is so important because it is one of the few tools to remedy racial discrimination that is still alive after the narrowing of equal protection remedies through jurisprudence that says you have to show a discriminatory purpose in order to use any kind of, in order to challenge racial classifications and win. So one thing that has come up a lot since her death has been some comments about her clerks and the fact that she has only hired one Black clerk during her career. She had 12% clerks of color. And I think one of the reasons for this has been the pipeline and the problem of there just not being enough people of color for her to hire. And that goes back to affirmative action and her belief in how important it was. So she consistently resisted the court's narrowing of affirmative action. And she did it in a very brilliant way, which was by highlighting the realities of life, while other voices in the opinion were speaking more theoretically she was bringing it back to what's happening on the ground. So in Adirond, she talks about how, quote, job applicants with identical resumes, qualifications, and interview styles still experience different receptions depending on race, how white and African American consumers still encounter different deals, how people of color looking for housing still face discriminatory treatment by landlords, real estate agents, and mortgage lenders, how minority entrepreneurs sometimes fail to gain contracts even though they are the lowest bidders. And then in Gratz, she also spoke about poverty and healthcare. So she really understood how this empirical evidence should impact the court. And she used this to push back against the idea of colorblindness, the idea that everybody should be treated equally, even though we don't have equal paths, equal histories. And the colorblindness ignores the history of slavery in this country and the subordination that followed. I also want to highlight in the Gratz dissent that she spoke about bias, both conscious and unconscious, and its function of keeping up barriers. And she cites to our own Professor Krieger's 1998 article, Civil Rights Perestroika, Intergroup Relations After Affirmative Action. So it's wonderful to look back at these dissents and see how we have affected Justice Ginsburg as an institution, and also how tenacious she was in resisting colorblindness and resisting the idea that we're all now in a post-racial world with a level playing field.
Thank you so much, Andrea. That was really very powerful. And thank you also for lifting up the role of scholarship in that important conversation and discussion that often takes place between the practice, the bench, the academy. Those connections always need tending. And so it's always fortifying and enriching for faculty members to see that their work has impact, especially in such a momentous and incredible way. Justice McKenna, are there any particular dissents that you would like to speak to and underscore as particularly impactful? Or
I would. I'd like to focus on several, but the first one was her 2007 dissent in the Lilly Ledbetter case, which was a gender discrimination case in which a woman who had been employed by Goodyear for a long time was not receiving the same pay as men that had entered the company at the same time as her. And talking about, how Professor Freeman talks about how she would tell stories and be real, and just, she made it very clear that Lilly Ledbetter, after a certain number of years, was only making $3,727 per month, compared to the men that entered with her. The lowest was $4,286 a month, and the highest was $5,236 a month. She made things real, talked about how things actually impacted people. And in that case, the United States Supreme Court basically rejected the gender discrimination case on the basis that the plaintiff should have, it was basically statute of limitations, that she had to be filing claims every paycheck, basically. And because she did it, she couldn't now complain about not making as much. And what was brilliant about Justice Ginsburg is her awareness and understanding of the roles of the three branches of government, and how she said, she was talking back, there was a 1991 case also where the United States Supreme Court had made a really limited and what she considered a very bad ruling in terms of gender discrimination, in the Lawrence case. And the Congress actually overruled the United States Supreme Court. So in 2007, Justice Ginsburg once again said, once again, the ball is in Congress's court. As in 1991, the legislature may act to correct this court's parsimonious holding of Title VII. That's the gender discrimination in employment law. And so what I think is really important is that she made sure that people understood that when United States Supreme Court decisions were based on statutes and not the Constitution, if it was a statutory interpretation case, Congress is free to overrule that decision. And I'm just going to talk about two other dissents that she wrote that were based on statutes. The 2014 Hobby Lobby case. 5 justices, the majority ruled that the Religious Freedom Restoration Act of 1993 allowed Hobby Lobby not to cover, not to require, the 2010 Affordable Care Act had regulations that required employers to cover 18 forms of contraception in their health insurance plans. And she had so many brilliant statements in her dissent. She pointed out all the problems with that holding. But what was really important was that this was based on the Religious Freedom Restoration Act and not based on the Free Exercise Clause of the First Amendment, which this ruling would not have survived a free exercise, could not meet a free exercise challenge. So that is a statute, and that's all I'm going to say. And another dissent that she, the Shelby County versus Holder case, and that was the decision, the Voting Rights Act case, the 1965 Voting Rights Act case. The court in that case, the majority did find the act unconstitutional on the grounds that the blight of racial discrimination had been ameliorated by 2013. But it was based on the statute, and it appears that if more recent events can establish that perhaps the Voting Rights Act has the problems that were to be addressed by the Voting Rights Act have not actually been completely addressed. I wonder whether or not Congress might be able to pass something that will pass constitutional muster. And I just love her quote in that case from her dissent. Throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet. Such poetic language, and I just have to say that I just want to also comment that, she had this wonderful knack of, in her majority opinions, basically telling the story at the very beginning. And, she talked about how she would write her opinions so that people that were just generally interested could just read the beginning of her opinion and understand what the basic ruling was, instead of having to try to decipher. Supreme Court opinions are difficult, even for judges and lawyers to understand. So she had this wonderful writing style that made it clear what she was trying to say. And she did that in her dissents also.
Thank you. I think that's a crucial point as well. And it speaks to her desire to make the law accessible, right? And to make sure it resonates across our society in ways that enhance our democracy, right? If it's only within the exclusive domain of certain individuals who can translate it, it really doesn't have the reach that it otherwise could. And she's a remarkably brilliant jurist who was also incredibly readable, which is part of her brilliance.
Right.
Which is part of her brilliance.
Right.
And I also want to, before I pivot to Professor Law, Justice McKenna, I want to thank you for highlighting her jurisprudence that indicates that the costs of discrimination on whatever basis, race, ethnicity, gender, sexuality, class, etc., and the intersection of all that we know, has real implications, right? Spiritually, mentally, physically, and often financially and economically, right? And these are often devastating and long-lasting consequences that accumulate over time.
Right.
And Professor Law, I was going to call you Justice Law.
You can call me Sylvia, that works.
But Sylvia, Professor Law, are there any additions that you'd like to make to our conversation about the power of her dissents?
Well, I think since 2006, Ruth's major contribution, apart from VMI, has been in the form of dissents. And most brilliantly in the Ledbetter case, she not only explained the law in lucid terms, she wrote the statute for the Congress and she read it from the bench and she said, go get them, guys. And looking forward, we can't count on the court for good constitutional rulings, assuming we elect a Democratic Senate and president, then Congress can follow the blueprint that Ruth has left them in many, many areas. The Affordable Care Act case that Justice McKenna talked about, the majority opinions on the Religious Restoration Act and the Affordable Care Act are literally incomprehensible. I do not suggest to anyone that they try to teach those cases because they're not teachable. But then Ruth comes in and she does the dissent and she says what the statute said and what the problem was and how Congress can fix it. So Congress needs to fix that problem, and it's fixable. It's not constitutional, it's just a statute. Another favorite in that genre is a 1918 case, 5-4, that read the 1925 Federal Arbitration Act to effectively bar employees from seeking class relief under the Fair Labor Standards Act. So employers are not complying with wage and hour legislation, but when they hire people, they make them sign a little piece of paper or they put it in their pay stub saying you won't bring any class actions to enforce the Fair Labor Standards Act. Ruth says, no, that's not what the statute says. It's fixable. She explains how you can fix it. There are many, many cases like that. I think the most important and most complex might be Shelby County, where the court struck down the pre-clearance provisions of the Voting Rights Act that are absolutely critical to enforcing equal access to the ballot. Rewriting the Voting Rights Act, she didn't rewrite it for us, and it will be a complicated job to do it because there are constitutional issues at play and we can't win on constitutional issues. But I think that we can write a Voting Rights Act that brings back pre-clearance in a form that at least has a shot of being upheld in the Supreme Court. And she has literally dozens of these statutory cases, and I urge law students and lawyers to read her dissents because you go read the majority opinion and you think, this is too much in the weeds for me, it's not important. And then you read her dissent and you go, oh my goodness, this is terrible, and something can be done about it.
Thank you, Professor Law. And talking about complicated jobs, how do we go forward in carrying forward her legacy? Right? So first part of that would be, let's talk about her legacy. And the second part would be, what do you think the court looks like going forward? Right? And that I'm trying to weave in some of the questions from our audience as well. What does diversity look like on the court? Including diversity of thought, but what are your best prognostications based on your incredible expertise? And I'd like to start, if I might, with Justice McKenna. What do we think about when we think about her legacy and how we go forward jurisprudentially and just this power of this incredible court? What do you think is going to happen?
Well, the United States Supreme Court is the Supreme Court of the country. And I don't know exactly what's going to happen with this latest nomination. I really don't know what's going to happen. But obviously there has been a much more conservative trend in recent years. I think that her legacy is her decisions, obviously, that are based on constitutional principles that I hope will be respected down the line. But also in terms of the, as Professor Law has said, the road maps that she has created in terms of if Congress is inclined to pass some of her laws, depending on who is elected, these roadmaps will become very important in terms of advancing the law, protecting healthcare, protecting civil rights, etc. She obviously leaves a huge legacy for women and discrimination of all types. And I think one thing that I would like to comment on is, and I'm not entirely sure who is in this audience, but I will say that if the United States Supreme Court becomes more conservative, in one sense, I believe it actually elevates the importance of state Supreme Courts. Because what a lot of people don't realize is that each state has its own constitution. And each state's Supreme Court or court of last resort is free to interpret its own constitution, which has language that could be identical to the United States Supreme Court, to provide greater rights under that state's constitution than is provided under the federal constitution. Now, there are certain areas that we can't do that, like arbitration, where Professor Law mentioned, because those provisions are based on the Federal Arbitration Act and federal preemption. No matter how much a state Supreme Court would not want to enforce an arbitration clause, it must follow federal law that preempts state law. And arbitration is one of those areas. But as Professor Law has said, that is something that can be amended by Congress, actually, in terms of the Arbitration Act, because it's not just employment, it's like consumer contracts now. You know, if you have a 5-cent claim, there's no way you're going to go to court. You can't have a class action. You can't go to court. You have to arbitrate a 5-cent claim. Nobody's going to do that. And so these huge companies can get by with basically consumer, basically treating consumers unfairly. And so I think laws like that need to be changed. I think she lays a legacy on how the laws can and need to be changed. And I think, but especially with respect to her cases on discrimination, whether as an advocate, there's one question here. Was her role as an advocate or as a justice more important? It's her entire legacy. They're just both as equally important. She has laid groundwork. She has created, and she has inspired so many people. So many people. I just wanted to actually ask Professor Law, Justice Ginsburg got to be known as Notorious RBG based on a video that was created by some law students. And one was an NYU law student who passed away soon after graduation in 2015. I was wondering, Professor Law, did you know her? Did you know Kelly Crosby?
I did. I knew that group. They worked for my friend Janet Benshoff, who was to reproductive freedom what Ruth was to gender equality more generally. And she died a few years ago. But they worked for her at the Global Justice Center. And I don't know why they had time off of work, but they created this whole meme and music, and Ruth loved it. It was not her style, but who could not love it,
And I loved how she would then claim that, me and Notorious B.I.G. have so much in common.
We're both from Brooklyn.
That speaks again to her reach, though, right? And I think she, Justice McKenna, you elevated the tactician in the jurisprudence, the tactics, right? Having the excellence in advocacy coupled with the excellence in strategy. And I think what you're both saying is also there's a brilliance in understanding the pervasiveness of culture and how the law can be spread, and we can learn more about the law and how it works through pop culture too, right? So speaking to young people in a way through these memes, I mean, how incredibly sophisticated and forward-looking is that? Right. So, I mean, kudos to her as well for recognizing the power of new ways of sharing information and as being part of important conversations to a whole generation, hopefully of future lawyers.
Camille, let me just say, I think that the legal academy, we all sometimes drop the ball or take our eye off the prize when we elevate constitutional law above smart legislation and state court law. And I understand that there's something so magnificent about claiming the right under the federal constitution, and it applies every place, and et cetera and so forth. But I think we really have to be serious about helping students learn how you write laws at the federal level that can undo some of the damage that's being done by the Supreme Court, and how we look to courts now that at the state level. Now the difficulty with that is it makes us more and more a nation in which we have the red states and the blue states. And the red states, we have reinvigorated equal pay acts and all kinds of good comparable worth and all kinds of good stuff. And in the blue states, we have criminalization of abortion. And so the state has its limits as a forum for advocacy, but law schools need to do more, I think, to focus both on legislation and on states.
That's really important, Professor Law. Thank you, Sylvia, for reminding us of that, and also for speaking directly to students as they also are thinking about course selection and designing their degrees for greater impact and, frankly, for leadership going forward, right? Because they are the next generation of jurists. And I just want to allow you a few minutes, if you want, Sylvia, to speak to her legacy before I allow Professor Freeman to have the last word before we have to wrap up. Would you like to comment any further on the legacy of Justice Ginsburg?
Just that she will be missed. Yeah. You know, she was just an amazing, remarkable woman and a force of nature.
Yeah, well said, well said. Andrea.
Yeah.
What do you think are the extrapolations of her jurisprudence and of the incredible impact she's had on a life in the law?
I've been thinking a lot about how we move forward with her principles and everything she's given us. And my thoughts have been going toward the next phase of gender justice. She did so much for us in thinking about equality between women and men, but it was a very binary type of analysis. And now I think, especially as you're noting, thinking about the next generation and the new awareness we have about gender and it not being binary, and we have gender non-conforming, we have non-binary, we have trans people, we've got a spectrum of gender now. And I think that we need to now take the lessons she gave us and reshape them to adjust to how gender equality looks, taking account of everybody. Because some of the things she has talked about, the physical differences between women and men, the inherent differences that she called cause for celebration, and they are, our conception needs to be expanded to include everybody on that spectrum. And I look to the young generation to figure out how we're going to do that.
Yeah, no, thank you for that. And I want to open it up to see if Professor Law or Justice McKenna want to add anything further with respect to that, or in particular, one of the a couple of the questions, you know, again, predictions about whether there will be, for example, an African-American woman on the court, or, you know, competing notions of feminism. These are our last few minutes before I have the privilege of thanking you all and thanking our great sponsors.
If I can just jump in here, what Professor Freeman said, you know, yes, I think you'll notice that at least in some of our opinions, my opinions and my colleagues' opinions, we have gotten away from the binary, getting away from the he or she, and we've started using they, them, their as a singular pronoun, just to get away from the binary. And I think that's really important. Also, I think, I actually want to ask the question that's asked. In terms of a Black woman on the United States Supreme Court, I don't know. I mean, one of the candidates has said that if he is elected and there's an opening, that's what he's going to do. So we'll see what happens. But I do want to ask Professor Law, one of the questions is, do you think Justice Ginsburg would have had an opinion on the expanding the number of justices on the court?
I think she would have been very cautious about that. I mean, she had a big vision in terms of justice, but her approach was radical in its vision, but extremely incremental in understanding how change takes place, which is in baby steps. So I think she'd be, but on the other hand, we're confronted with a situation which is just unprecedented in our history. I mean, the notion that a president can nominate a woman who is selected for the purpose of resolving a disputed election in which he's going to get reelected without the popular votes for a second time. It's just mind-boggling. and maybe it calls for something. I don't know. I would love to hear Ruth's views on whether there should be a big movement to insist that she recuse herself from election cases. Not from all cases, because obviously new justices pass on cases that the person who appointed them helped to write and wanted or didn't want or whatever. But it just seems so, I think a lower court judge or a state judge or a federal circuit court judge would perceive that there is an appearance of impropriety where you rule in a contested case about whether the guy who appointed you actually won the election. I could be wrong about that, but we'll see.
And I want to end on a bright light, because Justice Ginsburg, it's an incredibly challenging time, right? We have a global pandemic, everybody knows the numbers. There is such a fraught tenor and tone to the national discourse that it can be an incredibly destabilizing and demoralizing time. Yet she was such a bright light, and even as in some cases the only one, in some cases speaking with a powerful yet quiet voice, she had such an impact, and there's hope in that. So, and we also have to, I think, draw inspiration from her durable and long-lasting friendship with Justice Scalia, right? That, they were on opposite sides on many things, and yet still, they had this remarkable friendship. So I'd like to ask you to tease out one of the summarizing glimmers of hope that we can all draw strength from in terms of her life. Was that a hard Socratic question?
She beat odds, right?
Say that again, Andrea, sorry?
I was saying she beat all the odds.
Yeah.
She was so tenacious and persistent, and where so many people would have given up, she never did.
Yep.
Well, and her work, her prodigious hard work. I mean, she had fun. She liked having fun, and she liked being social, and a glass of wine and riding a horse and paddling and all the rest. But she loved Hawaii. But she worked in ways that I couldn't keep up with her, and I'm known as a hard worker.
Right.
I think also, sorry if I just say one, but her life work balance and her parenting and her home duties is something I think we all really need to see right now, because we're all being so challenged with the pandemic, with having to care for people at home and others while work 3 times or 10 times as hard. And she's really inspiring in that regard.
Great points.
And her relationship with her husband and how he supported her and how they were actually truly a partnership.
Yes.
And how
each other's biggest fans, and it was a deeply intellectual relationship as well as other things, but they just admired each other.
Yeah.
And, you know, her friendship with Justice Scalia, you know, I never got to, I'm sure Professor Law probably saw them together. I never got to see them together. I met them separately, but I can see, you know, Justice Scalia, he really had a charm.
He's one of the funner judges.
Yeah, he was actually
justices.
Really
nice
guy,
apart from his views.
Yeah. So you could see why, you know, people even with such different ideas could actually get along and enjoy the opera together. And it really, really is important. And as Professor Law has said, you know, I really do want the Congress and the United States Supreme Court to create the law of the land that applies to everyone. We don't want these patches of red states and blue states. We want everyone in the country to have basic rights and to be treated equally and with dignity in all aspects of life. That's what we want for everyone. And so, you know, I guess personally, when you become a justice, you become, for us, it's just one of 5, there's only 5 of us, but you really do start to think about things differently than you did even as an attorney, or I was a law professor also, or as a trial judge when you're just alone. When you come to a court and you hear from other people and you actually have the time to really think about a case and the ramifications and everything, I think things, I hope, will come a little bit closer together. And I hope that there will be decisions and you can sometimes never tell about a justice when they join the bench, right? Even some of the more recent justices, they've rendered opinions or have cited on cases that people are shocked at which way they went. So you just really, really never know. So that's my hope for the future. And I do think it's important for people to communicate and speak to each other.
Beautiful. Well, thank you all. And thank you all for bringing your full selves into the conversation, just as Justice Ginsburg brought her full self into everything she did. And just personally, also thank you for your laughter and your smiles, especially as we're grieving a massive loss of an iconic person who was just so dear to so many people. And I want to thank you for that, and thank you for your incredible insights. I also want to thank our sponsors, and I want to make sure I don't miss any of our event sponsors, so allow me to make sure of that. Thank you to the Hawaii State Commission on the Status of Women. Thank you to Kanu Hawaii. Thank you to the Scholars Strategy Network. Thank you to King Kamehameha V Judiciary History Center. Thank you to the YWCA of Oahu. And thank you to the Jewish Community Speaker Series at Temple Emmanuel. And I just want to put a plug in for an event that the YWCA of Oahu will have in October. It's October already. On the 24th of this month, they will be having an event that is a multi-organizational event honoring the life and the legacy of Justice Ruth Bader Ginsburg as well. So thank you all for joining us. I wish you all the best. Stay safe. Bye-bye. Thanks, everyone.
Bye.
Take care. Great seeing you all.